and I patiently heard three very eminent speakers, including Manzoor Bhai's opening remarks. So the house rule is please keep your questions short. Even if you want to put a statement, let the statement be, a kind of a question rather than a speech. So the more we have, we can let the three speakers come back and respond. If you have a particular person to address the question, please do mention. But when you begin, please do introduce yourself. And just for your information, the whole event is being live streamed as we speak. So the floor is open. Yes, Munir, go ahead. Yeah, there is a mic. No, mic is there.
Thank you.
Yeah.
This is Asif Munir. I work as a rights activist. I'll straight go to the questions, and perhaps this is to the two legal experts, but feel free for others as well. Just being a devil's advocate, because as we live stream, I'm sure Myanmar and their allies are also watching this and strategizing as well. What if the crime is committed in no man's land or neutral border territories, whether it's in terms of territorial jurisdiction, whether it's coercion, threat to life, what happens then? The other question is, can Myanmar file a petition against any kind of investigation or persecution in the name of state sovereignty? Thank you.
Ambassador Munshi, please. The mic.
Thank you, Professor Imtiaz. I have two questions. Number one is, of course, they all come out of my ignorance. I'm Munshi Faiz Ahmad, Chairman BIISS, Bangladesh Institute of International Strategic Studies. So the questions are, of course, born out of my ignorance, basically. Do we know that the UN has, a few years ago, decided on this provision for a right to protection, R2P. Does that in any way give the ICC another avenue for jurisdiction in this regard? That is a question that, because I do not know, I ask. The other one is that came to my mind when I was listening to Honorable Philip Radok, MP, about the Chinese interest in this matter and BRI being the crux of the Chinese interest, as he was suggesting. But I wonder, whatever happens today, and once these issues are resolved, China will continue to be China, India, and Russia. They will all continue to be important to Myanmar, whichever regime is there. So why should these countries feel that their interests are threatened if they are taking the current regime to task? Thank you.
Can we have one or two more before we come back to the panel? Anyone? Yeah, please. Introduce yourself and just wait for the mic. Just wait for the mic is there. Yeah.
I'll hold on to it.
Assalamu alaikum. I am Barrister Mahfuzur Rahman Milon. I am Advocate Supreme Court of Bangladesh and Executive Director of Justice House Foundation. We all know about mass killing of Rohingya people. So far I know that mass killing is still not being officially termed as genocide by United Nations. Rather, it is being termed as ethnic cleansing. My question is, why still now that mass killing is not officially being known or termed as genocide by United Nations? Thank you.
Let's go for one more and then we come back to the panel. Anyone from the back? Yes, please. Yeah, the mic.
Thank you to the honorable speakers for such informative presentations. I'm Takbir Huda. I'm a research specialist at Bangladesh Legal Aid and Services Trust. I actually have two questions. The first is a rather generic question that may be answered by any of the panelists, and it is, what specific role can NGOs like BLAST play to build up the momentum in terms of building accountability of the actors with regards to the Rohingya crisis? Mr. Radak mentioned documentation. So is there anything more that we could do, or is there anything specific? Do we just record witness statements, or we have a legal question, and it is to what extent does the Bemba case help us with regard to the gender-based violence that are taking place in Myanmar with regards to the rape, a genocidal rape of Rohingya women? I was actually referred to this case by Ms. Pramila Patten, the UN Special Representative on Sexual Violence and Conflict. So I would want to know, because I believe this is the first case where the ICC recognized rape as a crime against humanity. It was against the former rebel militia leader, Jean-Pierre. So, thank you.
Ambassador Tariq Karim, the mic, please.
Tariq Karim, I'm a retired diplomat, now with the BRAC University. I have one comment and one question. My comment is, particularly having listened to all the distinguished speakers, that Bangladesh as a responsible member of the international community has a duty to uphold and further strengthen the regime of international law for crimes against humanity. We have ourselves conducted it because we, what I've described as the original sin, did not address the crimes against humanity in 1971. My question is, what if for any reason Bangladesh fails to meet the deadline of responding to the ICC? What will be the cost? And perhaps the distinguished panels can address that. Thank you.
Thank you. One more and then we come back to the panel. Brigadier Shakwat.
Thank you very much. I'm retired Brigadier Sakhawat Hussain. Just follow up the Ambassador Karim's statement. What are the implications that Bangladesh may have if it responds positively to the ICC? Perhaps Imtiaz will be able to tell it. How much Bangladesh would lose in international arena, or its diplomatic or financial matter, like countries like China, Japan, India, Russia, how they would take it. Thank you.
Okay, let's start with Vice Rifat. Rifat, you want to go first to respond? Can you bring a mic, one of the mic, please? Yeah. And then we go to Kate. Yeah.
Can I pick the questions
Please.
randomly?
Please.
Yes. I'm grateful that the issue of R2P has been raised, and it figures happily prominently in the Dhaka Declaration. And what it says, the Dhaka Declaration says, is that recognizing the concept of responsibility to protect R2P that obliges the international community to protect refugees through multi-pronged interventions aimed inter alia at deterring occurrences of egregious international crimes like genocide, war crimes, ethnic cleansing, and crimes against humanity, and at holding the offending state to account. The Dhaka Declaration, which was the product of a 2-day conference, I think there was a consensus arrived at that, at least in theory and within the permits of the law and international declaration, there are no barriers or there are no impediments to an affected state like Bangladesh operating on two levels in tandem. Trying to achieve a resolution to a crisis through diplomatic means, while at the same time invoking the international community's duty under the circumstances to extend protection not only at seeking a durable solution to the plight of the refugees, but at the same time, if need be, pursuing a judicial settlement of the dispute. So in theory, that is permissible under international law. Barrister Mahfuzur Rahman Milan, he said, why aren't we using the genocide word? The very concept of R2P is based on an understanding that in certain cases, a particular state will abdicate its responsibility to protect its own citizens within its own borders by resorting to egregious crimes and violence. And specifically, there is reference to the G word, genocide. And we've come to recognize that at the earlier forum in April. And R2P recognizes that it is specifically because of these crimes being committed that the burden of protecting victims of genocide and other heinous crimes, egregious crimes, to shift compulsorily, mandatorily to the international community. So the G word is being used. There was a question from Blast, what could be done with regard to the NGOs putting in their worth in the effort at documentation. I take you again to the Dhaka Declaration, and there at, I think, Declaration number 15, I think, point 15, there is mention of supporting the UN Special Rapporteur on Myanmar with regard to the Special Rapporteur's recommendation to establish a documentation structure to collect, map, and preserve evidence of human rights violations and abuses and testimony from refugees in Cox's Bazar, and call upon the UN General Assembly to implement the recommendation. On a personal note, our guest of honor referred to his experience in visiting the refugee camps in Hong Kong when thousands of Indo-Chinese refugees all over Southeast Asia were part of a comprehensive plan of action in seeking a durable solution to their plight. And part of the comprehensive plan of action was the role of the UNHCR that was recognized exceptionally by states all around the region to engage in status determination of the individuals as refugees or not. And it was through that process that effective oral and documentary evidence was collected of the sustained, continuous level of persecution of individuals in Vietnam. We may not, at this point in time, want to go into the mechanism of status determination, but we can take a leaf from the UNHCR's experience as to how to collect this information by making it clear to our constituents, as it were, the refugees here, that it's being collected for a purpose, to probably to facilitate their return in safety and dignity, and also to hold Myanmar accountable. I leave it at that.
Kate?
Thank you. I'm kind of glad someone asked the no man's land question, but also scared by it. It's really the crux of one of the issues with deportation, and one that has been discussed a lot in academic commentary on the application. I think one of the ways to get around it is very practical. You know, many borders have a no man's land, right? You get to the border, you show your passport, you get into no man's land, you get to the next border post, and then you cross. And I think to start talking about crossing an international border as being that first point of crossing is going to cause a lot of complications legally for jurisdiction over these crimes. And some amicus have already dealt with this by saying it's entry into the next state. And actually the wording of the elements of crime, where they say to another state, would effectively deal with that. I think we have to be practical about these things. If you're talking about the crimes themselves being committed in no man's land, then that's a different issue. And I think then there's a lot of other jurisdictional factors at play. It depends how many elements of the crime, who the people were, what their nationality was, and therefore territorial jurisdiction might not have such a significant role. I mean, this is really a similar issue with the high seas, and that issue is ordinarily dealt with by, the nationality of the boat, the nationality of the perpetrators. So it really depends on the circumstances. But yeah, absolutely, this is going to be something that they're going to probably have to deal with. Your second question on Myanmar filing a petition. It's an interesting question in terms of process, because there is effectively no process set out under the Rules of Procedure and Evidence. But normally at the preliminary examination or investigation stage, confirmation stage, trial stage, the affected state has the right to make submissions. So I don't see why Myanmar couldn't file a submission in this case. They can only get rejected by the court as being premature, but they are an affected state, and if they wanted to file submissions, I expect that they probably could. On the R2P point, I think you've already covered it, but I just would want to say, in terms of the ICC acting on the notion of R2P, there's just no jurisdictional basis for them to do so. I mean, it's as the Honourable Justice set out, it's really Security Council referral, state party or state referral, and that's it. In terms of the UN not recognising genocide, again, you've already commented on this, but I wanted to add, and I'm a consultant with the UN. I'm not here in my capacity with the UN, and I haven't worked with them while they've been deliberating over this, but I know from experience that proving genocide is a very difficult thing to do. What makes genocide is the special intent of the perpetrator. Yes, there have been loads of acts committed which constitute genocidal acts, and they're not just mass killings, sexual and gender-based violence, it's torture, it's a range of other acts. But to prove that someone had the intent to destroy that group, or in whole or in part, is extremely difficult. And it's something that many prosecutors at the international level have failed to do in circumstances which are not dissimilar from what we're seeing now. So I think there's caution in that respect. I also think, though, and this is going to a point that you made about R2P and genocide, I would argue that it's not just genocide that compels states to act, that they should be compelled when it's a crime against humanity. I mean, labelling this as genocide or not, this is, nearly 1 million people being pushed across the border. If states are not going to act on that, then they're not going to act on anything. The roles sorry, I'm taking up a lot of time here, but the role NGOs play, I think there's a lot of things that can be done, and it depends on your expertise and what you can really bring to the collective advocacy that's going on. And I think that's, in the form of, if you have legal expertise, making amicus submissions to the court, making filings to the court, it's one thing that I think can never go to waste is finding creative advocacy strategies with states and pressuring them to do something, pressuring them to act, because that is really where the problem lies at the moment. I would caution telling NGOs to go out and do documentation work. There are many, many, many organisations in Cox's Bazar doing exactly that, stepping over each other to get to the victims. There are some victims that are being interviewed 5, 10, tens of times, and there are repercussions to doing that. Yes, it's good to document the evidence. It's really important that we get that while the evidence is fresh and we don't lose it. But there's this principle of do no harm and not re-traumatising victims through that process. There is also the problem of having masses of evidence from the same victim, which eventually end up in a criminal process before the court. So I saw this in cases I worked on where you would have multiple statements from the same victim, and any discrepancy between those statements can be used to discredit their testimony. And so that in itself was problematic. So unless that's your complete modus operandi, unless that you're an expert in that, then I would really caution against going out and doing that. I'll talk about Bemba because I think probably no one else on the panel will. Yeah, it's great that the court, after many stumbling blocks, finally has a case on on sexual and gender-based violence. They've developed some jurisprudence, and that jurisprudence will no doubt be helpful in future cases, particularly for accountability and who should be held accountable. I mean, Bemba wasn't always, a perpetrator of sexual violence, but he's been held accountable as a commander, and I think those links are often hard to make. So there should be some useful lessons and useful jurisprudence in there. I'm going to leave the political questions to Mr. Ruddock.
Fancy that. I think there are only two, and the